Hello everyone, welcome to Bajirao IAS Academy, the Hindu news analysis. Today is 19 December 2025 and today we have a list of topics for our discussion. So the first topic is India and Women Free Trade Agreement, and the second topic is restructuring of Mahatma Gandhi National Rural Employment Guarantee Scheme and its basic provisions, and passive euthanasia provision and a distinction between passive euthanasia and active euthanasia, and ad hoc judges and the constitutional provisions related to the ad hoc judges. So let's understand these topics in detail, and a first very important topic is India Women Free Trade Agreement. Now earlier in this class we have understood India Women relations in detailed way. So let's understand the free trade agreement between India and women and how it is going to improve the bilateral trade between these two countries. Now, one thing that you should understand that Oman is going to become the second country in the Middle East with which India is going to sign this comprehensive free trade agreement. Earlier, with United Arab Emirates, India already signed this comprehensive economic partnership agreement. In addition to UAE, now India is also going to sign this comprehensive free trade agreement. Right. So, in fact, on December 18, India signed this free trade agreement with Oman. So as I have already told you that Oman is going to become the second country within Middle East or West Asia with which India is signing the comprehensive free trade agreement. And also understand both Oman and UAE are part of the Gulf Cooperation Council. Now within the Gulf Cooperation Council, India has this comprehensive free trade agreement or comprehensive economic partnership agreement with two countries. Those two countries are UAE plus Oman. Right. So I hope you have understood this. Now, in fact, this agreement, the comprehensive economic partnership agreement between India and Oman, is considered as a strategic push from both the countries to further strengthen trade and in fact diversify the sources or export destination for India. Now one thing that we should understand here, what is diversification of exports? For example, if India is exporting too much amount of goods to countries like US and European Union, so India is now dependent on only European Union and US when it comes to exporting goods. However, what if US imposed tariffs on India's exports to US? Right? So that essentially means that if India is exporting goods to US while entering into US markets, those who are importing Indian goods need to pay certain tariff, a certain amount of taxes that they need to pay. So because of this reason, since those who are importing Indian goods in US, they need to pay higher prices to import Indian goods, which is tariff. And because of this reason, those who are importing Indian goods may not import Indian goods. Why? Because they are very costly because of US imposing tariffs on Indian goods. Now, if US is not importing Indian goods, then where Indian goods will go? Right. Now, in this context, India need to look for other countries. For example, countries in West Asia or Middle East, and countries in Africa, countries in Latin America, Southeast Asia, so that when we can be able to export our goods to number of countries, then even if these countries imposed tariffs on India, then we will be able to sustain those tariffs and we will continue to export things to different countries when we have diversified our export destinations. So with that objective, what India did? India signed this comprehensive economic partnership agreement with Oman, and in fact, India is also ready to sign such agreements with different other countries as well, as part of diversification of the export destinations. Now we'll have more countries to export our goods and we'll no longer dependent on countries like US and European Union, because they're very often coming up with tariffs on Indian goods. Right? Tariffs are a kind of a taxes. Right? Now let's understand What are the key features of India-Woman Comprehensive Partnership Agreement? Right. The key features and key provisions of it, let's understand this. Now first, it is talking about the market access and tariff liberalization. What exactly is market access and tariff liberalization? For example, imagine that if India is exporting goods to women. Now in fact, earlier a certain taxes that Indian goods need to pay before entering into the women markets. Now there will be no need to pay such taxes for Indian goods which are entering into the women markets. So that means those who are importing Indian goods in women no need to pay taxes for Indian goods. So that makes Indian goods cheaper. So that makes Indian goods cheaper compared to other countries' goods, and that's why women will start importing more amount of Indian goods. First thing, so which is the tariff liberalization and providing market access. Market access in the sense that earlier there are different sectors which may not be opened for Indian goods. So may not be opened for Indian goods in the sense that, for example, we'll take textile sector in women. Now what textile sector in women will do, that it will not accept imports from other countries, right? So the government will impose certain restrictions on this certain textile sector, that imports should not be allowed into textile sector because it may affect the domestic textile sector or domestic industries. However, market access means now those sectors which are earlier regulated are now opened for imports. So that means India can export these items into women. So one thing that we should understand, that more sectors will be opened, and apart from that there is no need to pay tariffs while Indian goods entering into the women's markets. So that means it will further strengthen the bilateral trade between India and women. However, now in fact, one thing that we should understand, that women has already offered zero duty access on almost 98% of tariff lines. So that means just pay zero tax or zero duty, right? So in fact, the tariffs are very common. So some countries imports 10% tariffs or 15% tariffs. So what is the purpose of imposing tariffs? Is to protect the domestic sector, right? So to protect the domestic sector, for example, I'll tell you one example here. Now, one thing that we should understand here is that the automobile sector, right? So the automobile sector. Now in automobile sector, there are number of companies in India which manufacture cars. For example, Tata manufacture cars, Mahindra manufacture cars. So different countries which actually manufacture cars, right? Now in this context, there is another car company which is Tesla, which is a US based car company. And this car company don't manufacture cars in India, but it manufacture cars in US, and it wanted to export its cars to India. However, if India has been importing those cars from US, then it will affect the domestic car manufacturing companies. So it will affect the domestic car manufacturing companies. Now, one thing that you should understand is Tesla is not having its manufacturing facility in India. Secondly, Tesla is not providing any employment opportunities to Indians, but Tesla wanted to sell its cars in Indian markets. So therefore, the government, in order to provide, on the other hand, Tata and Mahindra are domestic car companies. They are providing employment opportunities. They are contributing to Indian economy. So therefore, it is important to protect these domestic players. And because of that reason, what government will do? Government will import taxes. The government will say that don't import Tesla cars into India. Don't sell Tesla cars. Government will not say that, but government will impose high taxes, high tariffs on Tesla. So for example, now in this case, each Tesla car normally costs, right, around we estimate that each Tesla car normally costs rupees 25 lakh. However, so government wanted to encourage the domestic manufacturing companies, and therefore the government has imposed around 50% of tariffs. So imposing 50% of tariffs will make this car around 32.5 lakh. So therefore, this car, if Tesla wanted to sell this car in India, then those who are purchasing this car need to pay a higher amount of money. So this obviously discourages the domestic consumers who wanted to buy Tesla cars. So they will go for Tata cars or any other domestic cars. So that's the reason the tariffs are imposed, to protect the domestic economies, the domestic industries. To protect the domestic industries, the tariffs are generally imposed by these countries. However, what women will do, women will offer zero duty access to 98% of India's goods. So therefore, it will potentially benefit around 2 billion worth of additional Indian exports in near term, right? So $2 billion worth of additional exports near term. So therefore, India will export $2 billion worth of exports to women. And apart from that, India has also liberalized tariffs on around 77.79%. Now here, the comprehensive free trade agreement means not just India export its goods to women, but women also will export goods to India as well. So therefore, India needs to provide market access to women's goods, and India needs to liberalize tariffs. So as part of it, India has liberalized 77.79% of its tariff lines. India also protected its sensitive sectors. What are the sensitive sectors? For example, farming, agriculture, dairy sector. So these are some sensitive sectors. They are vulnerable sectors. For example, imagine that dairy sector is a vulnerable sector. Most of the women, poor farmers are engaged in dairy sector. However, if woman has been excessively exporting these dairy products into India, what about the domestic dairy companies or farmers, women who have dependent on this dairy sector? So these are sensitive sectors, and India protected such sensitive sectors. Those sensitive sectors are agricultural products, including dairy products, tea, coffee, rubber, and tobacco. So these are sensitive sectors where India has not allowed tariff liberalization. India has not allowed market access to women's products. And then there are some precious metals also, which is also considered as a sensitive sector, such as gold, silver, bullion, and jewelry. So these are some sensitive sectors, right? So by this free trade agreement, how Indian export will gain, how Indian exports will benefit, and what sectors will get benefited out of this free trade agreement. So there are some certain sectors, for example, textiles and leather, gems and jewelry, footwear, sports, and plastic and furniture. So these are the sectors which are going to benefit from this comprehensive free trade agreement between India and women. Why? Because these sectors earlier excessively dependent on US plus European Union to export these items. However, now they can export these items to countries like Oman, because Oman has almost reduced the tariffs on these exports. So that is how diversification of export destinations will benefit India's exports. Now, in this context, let's understand Oman's $40 billion annual import market, with nearly 2/3 comprising the machinery goods. So therefore, it actually presents a huge opportunity, huge potential for Indian goods, particularly in these domains that we have just discussed. And in fact, if you look at India and women's trade in the last 1 decade, last 5 years, in fact, in the last 5 years, India and women trade has doubled from $2 billion to around $6 billion. So this is a huge jump of the bilateral trade between India and women. Now, particularly we are talking about the India's exports. So India's exports to women increased significantly in the last 5 years. For example, 5 years back, India's exports to women stands at just $2 billion. But now Indian exports to women stands at around $6 billion. So therefore, there is a significant jump in India's exports, that including all these sectors: gems and jewelry, textile sector, footwear, plastics, everything. Now, in fact, because of this comprehensive economic partnership agreement, the bilateral trade between these two countries Particularly, India's exports to women will significantly increase, and it may be expected that it may reach $15 billion as well in the coming few years. However, so we have just understood how Indian exports, how certain sectors will benefit out of the Comprehensive Economic Partnership Agreement, how women's sectors will benefit out of it. There are certain sectors which may also benefit out of the Comprehensive Economic Partnership Agreement. For example, the concentrated in energy and industrial inputs, right? So particularly women exports to India, they concentrated in energy and industrial inputs. So India has imported 6.6 billion worth of goods from women in financial year 25. Now these goods that India has imported from women, including crude oil, liquefied natural gas, fertilizers, chemicals such as methanol and ammonia. Now in fact, most of these Middle Eastern countries, so they actually dependent on export of crude oil and natural gas. Export of crude oil and natural gas. So this is their biggest advantage, and India also imports crude oil, natural gas, and products which are associated with energy and industrial inputs. So therefore, women likely export these things to India even after the Comprehensive Economic Partnership Agreement has been signed, right? So woman is having advantage in these items. Right. Now, let's understand the other dimensions of this Comprehensive Economic Partnership Agreement. So because of this Comprehensive Economic Partnership Agreement, services, mobility, skilled professional now. So in fact, in Middle Eastern countries, the main problem is shortage of skilled workforce or shortage of workforce. Shortage of workforce is the main problem in most of these Middle Eastern countries, and that's why most of the Indians from Kerala and different other states go to Saudi Arabia, Oman, UAE for work. So because these countries traditionally face shortage of workforce in different sectors. But if you look at India, India is having the advantage. What advantage India has? So India has the largest demographic dividend. So what is demographic dividend? So demographic dividend means the working age population. So don't you think that India is having the largest working age population, right? So because India is now the world's most populous country, and along with that, we are also a country with a huge demographic dividend. That means we having a huge workforce. So when we have a huge workforce, now in fact providing employment to the all existing workforce is a challenge for Indian government. So because of that reason, unemployment has been increasing. So therefore, when we sign this Comprehensive Economic Partnership Agreement, why don't we have the mobility of skilled professionals into those countries? Because we have a demographic dividend, and those countries are also facing shortage of the workforce. So when we send the skilled workforce into those countries, then it will lead to the effective usage of India's existing demographic dividend, and it will also address the problem of unemployment, and it will also increase remittances to India. What are remittances? Remittances are the income so earned by those individuals in these countries, and they send that income to their families, which is called as remittances, and remittances will also increase significantly. Now, in fact, according to World Bank estimates that India is the country which has been receiving the highest amount of remittances in the world. So therefore, this remittances income will also increase for India. Now, as part of this Comprehensive Economic Partnership Agreement with women, now this woman has increased the quota for intra-corporate transfers from 20% to 50%. So that means, so there will be a more number of workers who will go and work in women. And secondly, this agreement also provides more liberal entry and stay conditions for the skill. For example, if you are a skilled individual and you wanted to work in women, now since you are already a skilled individual, women will easily give you visa, and you can also stay in woman and you can also work in woman, right? For example, certain areas, accountancy, taxation, architecture, medical and allied services. For example, if you are a nurse, for example, most of the people are from Kerala, so they work in medical and allied services, right? So if you are having such a skill, so you can apply for visa in woman and you can also work in woman, right? So this is what the more liberal entry and stay conditions. And this will help India support knowledge based export. Now this is what is called as knowledge based export, not brain drain, right? And it will also lead to the integration of professionals and employment generation for India's youth. This is the main concern here, right? So in India there is an unemployment problem, and this unemployment problem can be solved with the mobility of skilled professionals to other countries as part of the comprehensive economic partnership agreement. Now let's understand the strategic and economic significance of this free trade agreement or comprehensive economic partnership agreement. Now, in fact, Oman is considered, if you look at the location of Oman, very next to Arabian Sea, it is a gateway for West Asia and Africa. So India's access to West Asia and Africa, Oman is a gateway, right? Now, in fact, Oman's location is also a strategically very important location. And in fact, Oman will also play a very important role in it may act as an export hub. For example, imagine that if India wanted to export things to Saudi Arabia, UAE. Now first India can export things to Oman, and from Oman India can export goods to different other countries, and therefore Oman may act as an export hub for India, and Oman may also support the logistics to export goods to Africa and rest of the West Asian countries. And in fact, according to FIEO, this comprehensive economic partnership agreement, so this will further strengthen, further help the Indian companies integrate into the regional value chains and diversify export destinations. We have already understood. So Oman opening up its sectors, Oman providing zero tariffs or zero duty on Indian exports, so will certainly strengthen exports from India to Oman. And so it will also aligns with India's free trade agreement strategy as well. So free trade agreement strategy in the sense that as of now, India has been focused on free trade agreements with a number of countries, because we have understood the benefits of the free trade agreements, and apart from that we can no longer dependent on US and European Union because they are imposing tariffs on Indian goods. So therefore we need to diversify our export destination, so therefore we need to look for export destinations in Africa, West Asia, Latin America, Southeast Asia. So that's why India has been focusing on these free trade agreements. India has been expanding the free trade agreements, particularly in the context of US trade agreements. Also understand, recently US has imposed 25% plus 25%, 50% tariffs on Indian goods. Now in fact, once USA used to be India's largest trading partner. India used to export maximum amount of goods to US, but after Donald Trump elected as a president of US has imposed 50% tariffs on Indian goods, and that severely affected Indian goods, right? So what does it mean, 50% tariffs? For example, imagine that if India is sending a textile, India is sending textile or any cloth, the value of the cloth is 100 rupees to US. Now before entering into the US market, so this textile product, so they must pay 50% of the value of these goods as a tax. Only then they will be allowed into the US markets. So the total value would be 150. So 150 is very costly in US. So therefore, US importers will stop importing goods from India. So that's how the tariffs will discourage exports from other countries. Now, what will be the expected outcomes under the comprehensive economic partnership agreement. So if you look at the expected outcomes under the comprehensive economic partnership, so it will strengthen the economic and commercial integration, no doubt about that, this by increasing India's exports to women, and it will increase the bilateral trade. As of now, the bilateral trade stands at near about 10 to 12 billion US dollars. Through this comprehensive economic partnership agreement, the bilateral trade will also double, and it may reach 20 billion US dollars very soon. And then it may unlock the opportunities across different sectors, because women is ready to open different sectors for Indian goods, and it may enhance India's economic growth. It will result in job creation and even investment flows as well. So these are the benefits or expected outcomes of this comprehensive economic partnership agreement. Now, so India aimed at diversifying its export destinations, now which is called as export resilience. If one country is not ready to import India's goods, so India may have other countries to export its goods, and this is what is called as export resilience. And therefore, if India is having this comprehensive economic partnership with countries like Oman and UAE, India may also look for such other opportunities in other countries within West Asia, such as countries like Saudi Arabia. So all these countries. So therefore, it might lead to increasing India's footprint in West Asia. So therefore, women's market is smaller than UAE's market for India, but women will play a very important role as a regional gateway for India to export Indian goods to the rest of the Middle Eastern countries or economies. And in fact, economically and geopolitically also, women is very important, and this free trade agreement will further strengthen India's bilateral relations with women. I hope you have understood this. And the next very important topic is about passive euthanasia in India. So let's understand about the passive euthanasia in a very brief in a very brief way, right? So what exactly is passive euthanasia and active euthanasia, and what is the legal status of passive and active euthanasia? Now, euthanasia actually refers to the deliberate act of ending euthanasia refers to the deliberate act of killing an individual or ending the life of individual. Ending the life of an individual. For example, imagine that an individual who is suffering in a permanent vegetative state. Permanent vegetative state in the sense that they are in coma for like 10 years, 5 years and 15 years. They are permanently in coma, and family members have been paying a huge amount of medical bills to that person, and family members are also suffering a lot of trauma regularly looking at this individual in this state. Now the family members will decide that we don't want to see the suffering of this patient. We don't want to see the suffering of this individual. So end his life, right? So end his life. So therefore, the doctors will end his life, and it can be done in two ways. One is passive euthanasia and the other is active euthanasia. Active euthanasia. So I hope you have understood euthanasia. Euthanasia means any individual so who is in a permanent vegetative state. Permanent vegetative state means he's alive but he's in coma. So he's not responding to anything, he's not understanding anything. So he's permanently in coma on a hospital bed for several years. So family members don't want to see his suffering in the hospital. So therefore family members request doctors to end his life, and it can be done through two different ways. One is passive euthanasia and the other is active euthanasia. So these are two different types. So I hope you have understood what is euthanasia. Euthanasia refers to a deliberate act, deliberately, intentionally ending a person's life to relieve suffering from an incurable or terminal illness. However, the Supreme Court has taken up the debate about the euthanasia, whether this passive euthanasia should be allowed in India or euthanasia should be allowed in India is a question that Supreme Court has taken up, because Supreme Court has already recognized that right to live with dignity is part of Article 21. So therefore, there is a huge debate about this euthanasia. And in fact, Supreme Court has also recognized right to die with dignity, not just right to life with dignity, but right to die with dignity is also recognized as part of Article 21. If you wanted to die, die a dignified death. Right? So that has been recognized by the Supreme Court as part of Article 21, and that is related to euthanasia. Right? Now, in fact, in India, active euthanasia is illegal. Understand? Active euthanasia is illegal. It is a crime. However, the Supreme Court in number of cases allowed passive euthanasia. We are about to understand the difference between passive euthanasia and active euthanasia. Right? So active euthanasia is illegal. It is a crime. But passive euthanasia is allowed in India in certain conditions. In certain circumstances, Supreme Court has allowed passive euthanasia, but Supreme Court is not allowed active euthanasia. It is a crime. Right? So therefore, in this context, let's understand what is the difference between active euthanasia and passive euthanasia. Now, as I've already told you that active euthanasia is illegal in India. Supreme Court has not allowed active euthanasia, and active euthanasia is a crime. Now, what exactly is active euthanasia? Now, in fact, a doctor giving a lethal injection to end the life of a patient is considered as a active euthanasia. Right? So it is a direct intervention to cause death, such as administering a lethal injection. Right? So doctors or a medical staff, what they do, they give a lethal injection, a poisonous injection to kill the patient, to end his suffering, which is active euthanasia. However, in passive euthanasia, what will happen? Passive euthanasia involves withdrawing the life-sustaining treatment. For example, if there is a patient who is on a bed and this patient also survived by certain life-supporting systems. For example, oxygen is needed, and so other, they may not be able to eat food, but they will be given these nutrients, so all necessary things through saline bottles and all. Now, in passive euthanasia, they simply withdraw those life-supporting systems. They will not give lethal injection to kill the person, but they just withdraw or withhold the life-sustaining treatment, such as they may be on ventilators, so they will withdraw the ventilators. And there will be no artificial nutrition for the individual. Because if they are in a coma or a permanent vegetative state, they may not be able to eat food. So therefore, there will be artificial nutrition which will be given through like saline bottles and all, and it will no longer be provided. So understand the difference between active and passive euthanasia. In active euthanasia, lethal injection will be administered, and that will lead to the killing of a person who is in a vegetative state. But in passive euthanasia, just the medical staff will withhold or withdraw these life supporting systems, including ventilators and artificial nutrition. So as I've already told you that active euthanasia is illegal and a crime in India, because it amounts to killing a person by a doctor. Right? So it is a crime under the Indian Penal Code. And in fact, Supreme Court has also not approved and not allowed active euthanasia. That means even if a person is going through a vegetative state, a permanent state of coma, you cannot give a lethal injection to kill the individual. Right? So therefore, no judicial approval and in fact no statutory framework that currently allows active euthanasia in India. However, Supreme Court has permitted passive euthanasia in certain cases. So it has been legally recognized in India under strict safeguards. It has been allowed, but that too a very strict safeguards. Strict monitoring is required based on the principle of allowing natural course of death. Now once you withdraw this life supporting system, so it may over a period of time leads to the death of a patient who is in a permanent vegetative state. Now this is the difference between active euthanasia and passive euthanasia, right? Now in fact, in this euthanasia matter, a very important case that we need to understand. So the case is Aruna Ramchandra Shanbag case. So Aruna Ramchandra Shanbag is a nurse who is working in a hospital in Maharashtra. Right. Now, in fact, she was brutally raped by a ward boy in that hospital. So this happened in 1970s, right? So Aruna Shanbag rape case took place in 1970s. She was brutally raped and choked with a dog's chain. And after that rape incident, she went into a permanent vegetative state, right? So she was in coma, she was alive, but she did not have any senses, and she was not responding to anything. She was alive, but after this incident, she went into this permanent vegetative state. Now, when she was in this permanent vegetative state, the very same hospital this incident happened, it takes care of Aruna Ramchandra Shanbag. The hospital and the nursing staff used to take care of Aruna Ramchandra Shanbag. So, however, some NGO, some social activist filed a case in Supreme Court that so she has been in this permanent vegetative state for around like 30 more years. 30 years she is in that permanent vegetative state. So why don't passive euthanasia be allowed in the case of Aruna Ramchandra Shanbag? Now in this case, the Supreme Court has denied the passive euthanasia also. So why? Because social activist has no relation with Aruna Ramchandra Shanbag, but on the other hand, the very same hospital which has been taking care of the Aruna Ramchandra Shanbag has refused or not ready for this passive euthanasia. So therefore, Supreme Court has rejected the passive euthanasia in the case of Aruna Ramchandra Shanbag. So anyway, she died later in 2014 with some disease. Right? So with pneumonia or something, she died anyway. Right? Now, in fact, this was the first landmark case where Supreme Court has recognized euthanasia in India. Supreme Court has said that passive euthanasia is legal in India. Passive euthanasia is legal in India, but with respect to Aruna Shanbag case, this passive euthanasia was not allowed. Not allowed because the case was filed by some social activist who is not having any relation with Aruna Shanbag. But on the other hand, the nurses in that hospital are taking care of Aruna Shanbag, but they are not ready to kill her through this passive euthanasia. Because of that reason, even though Supreme Court has recognized the legality of euthanasia, so Supreme Court has refused. Supreme Court has actually denied passive euthanasia in the case of Aruna Shanbag. Right? So therefore, the court has laid down that it could be allowed with the approval from the High Court. So therefore, this is the first case where passive euthanasia has been allowed in India under strict guidelines or strict safeguards. So let's understand the constitutional recognition. Now, a very important case that took place in the year 2018 where the Supreme Court in Common Cause versus Union of India, the Supreme Court held that right to die with dignity is also part of Article 21. Now, Article 21 talks about right to life and personal liberty, right to live with dignity. Supreme Court held that right to die with dignity is also a fundamental right under Article 21 of the Constitution. So therefore, the Supreme Court in the very same case held that if a patient is a permanent vegetative state or a terminally ill patient, for them passive euthanasia might be allowed. That means withdrawing the life support system to those patients. So in fact, the very same Common Cause versus Union of India case, the Supreme Court has framed detailed guidelines for this passive euthanasia. Right. Now, this passive euthanasia is allowed in cases where there is an advanced directive, a living will, and cases where no such directive exists. Now, let's understand what exactly is the living will with respect to passive euthanasia. So, living will means, imagine that there is an individual, and this individual in his 40s or in his 50s of age, and this individual wanted to die with dignity. For example, he can write a living will. So this living will, when he was in 40s or 50s, when he is healthy, active, so he can write a living will that in case he is old and his family members are not taking care of him, or if he is in a permanent because of any reason, because of his old age, because of any other reason in future, if he goes into this permanent vegetative state, so please allow passive euthanasia for me. Please allow passive euthanasia for me, so that he may write when he is in his healthy age. Right, so he can write this living will so that he wanted to die with dignity in case he is in that particular state. Right, so that amounts to living will. So he can write the living will. So living will is a written document by a person who is aged above 18 years of above. So when he is having the decision making capacity, specifying their wishes regarding the medical treatment. So what type of a medical treatment that they wanted to receive when they lose the capacity in future. Because when an individual in a permanent vegetative state, he cannot write a living will. He cannot write a living will. Ultimately, the family members will approach the courts and ask the courts to allow passive euthanasia for this patient. But when this person is healthy, and this person may write a living will that in case if I go to a permanent vegetative state in future, so please allow me passive euthanasia, where family members approval is not required at that case, right? Therefore, so the living will must name at least 2 surrogate decision makers in this context, and it must be signed in the presence of 2 witnesses, and it must be assisted by a notary or a gazetted officer. So that these things have to be done if you are writing a living will. For example, in 2013, Justice M.S. Sonak of Bombay High Court, so he became the first person in Goa to register a living will. So he has written a living will highlighting increasing public awareness about this living will and passive euthanasia. Right. Let's understand the procedural reforms and recent developments with respect to the passive euthanasia. Now, in 2023, a 5-judge bench of the Supreme Court simplified a common cause guidelines to make these guidelines more workable. So that means it has introduced timelines for the medical boards to come up with appropriate decisions, and reduced the role of judicial magistrate, easing the procedural delays. And government has published a draft guidelines with respect to passive euthanasia in the year 2024. Particularly in August 2024, Ministry of Health and Family Welfare has issued draft guidelines aligning Supreme Court ruling. Now, what are the key provisions under this? The key provisions including formation of a primary and secondary medical boards at hospital level. So the medical boards will look into the condition of the patient, and medical boards will also come to the assessment that whether this passive euthanasia should be allowed or not in this patient's case. And then nomination of doctors by district chief medical officer to the secondary medical board. And these steps essentially aim to institutionalize passive euthanasia process across different states in India. Right. So therefore, this is active euthanasia and passive euthanasia in India. Now let's understand about the Mahatma Gandhi National Rural Employment Guarantee Act, because we have already discussed about this in this context. Now, the government is planning to restructure Mahatma Gandhi National Rural Employment Guarantee Scheme, which is a very, very important scheme at the grassroots level. It provides 100 days of legal guarantee of work to every rural household who is willing to do unskilled work, who is above 18 years of age. Right. Now, in fact, Mahatma Gandhi National Rural Employment Guarantee Scheme plays a very important role in addressing rural distress. It plays a very important role in addressing the rural distress, and it also prevent or eliminate distress migration. Why people migrate from rural areas to urban areas? Because they are not getting employment, right? So they are living in poor conditions. So if they go to urban areas, they may get employment, right? They may be able to sustain their families. However, how about providing employment in rural areas itself through schemes like Mahatma Gandhi National, so through Manrega, right? So therefore, it actually play a very important role in alleviation of poverty, alleviation of rural distress, and it also prevent distress migration of rural people into the urban areas. So that's why it is a very, very important scheme at the grassroots level. Right. Now, in this context, Manrega is considered as a rights-based welfare program in India in rural areas. The government has been planning to restructure the name through Vikasit Bharat, Guarantee for Rojgar, and Ajivika Mission Bill of 2025. Now, this bill is planning to repeal and replace MG Narega, and it marks a significant restructuring of the rural employment policy. Right. So what are the key changes which are proposed under Vikasit Bharat Gramin Rojgar Ajivika Mission Gramin Bill? Right. Earlier, under Mahatma Gandhi National Rural Employment Guarantee Act, so how many days of employment has been provided in rural areas? 100 days. So understand, this Manrega is only for rural areas, not for urban areas. But so under this Pujya Bapu Gramin Rojgar Yojana, so this number of days will be increased to 25 days. So every year 125 days of employment will be provided to every adult household who is willing to do the unskilled manual labor. However, so it is good that the government has been increasing the working days from 100 days to 125 days. So it provide a more number of work days for the rural poor. However, the government is also changing the funding pattern. So what type of a funding pattern? Earlier, the government used to give 90% funding. The central government used to give 90% funding, and state governments bear rest of the 10% of the funding. But under this new bill, the government has been restructuring Manrega, and funding pattern will be changed to 40%. For example, imagine the state of Andhra Pradesh. Now, in this state, so 100 crore rupees worth of Manrega wage or Manrega work has been conducted. Now, 60 crore rupees will be given by the center and 40 crore rupees will be borne by the states. Now, earlier 90 crore was given by the center and only 10 crores were borne by the states. However, so this funding pattern is different for the northeastern states and Jammu and Kashmir. So what should be the funding pattern? The funding pattern for these two types of states is still 90% and 10%. Right. So the funding pattern has also been changed. Now, in this context, there will be more expenditure burden on the state governments, because state governments now need to bear 40% of the total cost of funding, right? So therefore, it has increased the concerns about the feasibility of the program, especially the fiscally weaker states. Now, what are the implications of the restructuring of this Manrega program? Now, in fact, the Manrega became a demand-driven to budget-capped program. So demand, what exactly is demand-driven? So demand-driven means that, so how many workers, for example, anybody in rural areas, any individual, so how many individuals who wanted to work, so they can work under Manrega. So this is a demand-driven program. So this program will be transformed from a demand-driven program to a budget-capped program. So budget-capped program means that, imagine that if central government has allocated only 100 crore every year for this program, then only 100 crore work will be done. So after that, no work will be provided. So demand driven means even if it is more than 100 crore, based on the demand, the government must provide the funding. Right. So in fact, Manrega is also a statutory act. Manrega was a legal entitlement. Anyone who demands work, the government must provide employment for that particular person. However, this new bill has changed the program from the demand driven to the supply driven scheme, constrained by annual allocations which are decided by the center. And apart from that, even though the work days have been increased to 125, there are some seasonal pauses in the implementation of this new Manrega program, and there will be funding limits as well. So ultimately affect the implementation of newly restructured Manrega program. And apart from that, it will also create a fiscal stress on states because the funding pattern has been changed. And apart from that, more work days, that means states need to pay a more amount of money, and it could further leads to delayed payments, because now it depends on both center and state governments. If any one party delays giving funds, then there will be delayed funds, reduced work generation, and even uneven implementation across different states. That's the problem with this restructured Manrega program. Now, why Manrega worked? And in fact, Manrega is one of the most successful program. Now, in fact, the evidence shows that the household earnings in rural areas increased by 14%. Right? So there is a huge increase in the earnings of rural households, and poverty has also significantly decreased because of the Manrega program. Right? So Manrega program further strengthened labor bargaining power by increasing rural wages. Now, how it has increased rural wages or rural bargaining power? For example, imagine that there is a Manrega work has been going on, and apart from that, the landed farmers in rural areas or any other work in rural areas. So any other work in rural areas also require employees. Now, under Manrega, the government is providing 300 rupees even for men and women. So there is no difference. Men would be paid higher amount of wage, women would be paid lower amount of, there's no such thing. So women also paid 300 rupees of wages. So whenever there is a work in these rural areas, so they can opt either Manrega or land or any other work in rural areas. So if there is any other work in rural areas apart from Manrega, the woman would demand more than 300 rupees, only then they will come to this work. So therefore, don't you think that it has increased the bargaining power of women and other workers in the rural areas? Obviously, yes. So therefore, it increased the rural wages, it increased the rural demand, and it also led to the growth in non-farm employment for the women. And during COVID-19 pandemic, a unique migration pattern was observed, which is reverse migration. So reverse migration, that means people during COVID-19 pandemic started migrating from urban areas to rural areas. Now, when this reverse migration took place during the COVID-19 pandemic, Manrega has actually provided relief for most of these people. And in fact, during COVID-19 pandemic also, several people slipped into the cycle of poverty, and at that point of time, Manrega helped those people to stay out of this poverty cycle. So therefore, you can imagine how Manrega is very, very important scheme. So this scheme, even if it is restructured, there is a need to increase funding from the central government for Manrega, and there is a need to at the same time, so there is a need to make it a supply driven demand driven program rather than the supply driven program. Right? Now, the next important topic is about ad hoc judges in Indian judiciary. So let's understand this very briefly. There is a topic which has been given in the Hindu newspaper, right? So in fact, Indian judiciary has been facing a huge pendency of cases, which is a backlog of cases. So this backlog or pendency of cases is because of vacancies which are existing in lower courts and high courts. If there is a vacancy, if there are no judges, who will hear these cases? So that's why there is a vacancy and pending cases. So here some data which has been revealing us some details about the pending cases. So National Judicial Data Grid, it says that 18.98 lakh criminal cases are pending across 25 high courts and with over 68% pending for more than 1 year. What was the reason for pending cases? Vacancy of judges. There are no judges in high courts. If there are no judges, who will hear these cases? So they will be pending, obviously. Now, in order to address this crisis, Constitution has provided for appointment of a ad hoc judges. Ad hoc judges, so they will sit as judges of high court and they will start hearing the cases, and it will help reduce the pendency of the cases. So therefore, this mechanism of ad hoc judges provided by the Constitution has been revived by the Supreme Court recently. So let's understand what constitutional provisions are there for the ad hoc judges. There is an article 224A. Now what is this 224A says that? Now this article 224A of the Indian Constitution says that a Chief Justice of High Court with the previous consent of the President. So taking consent from the President of India, the Chief Justice of a concerned High Court may appoint a retired judge of a High Court as ad hoc judge. Now these ad hoc judges are retired judges of High Court. They are the retired judges or senior most retired judges of high courts. If a high court believes that there is a vacancy of judges and there is a backlog of cases, the Chief Justice of that concerned high court with the previous consent, with the previous permission of the President, can appoint a retired judge as a judge of a high court for a temporary period of time. So therefore, the ad hoc judges are temporary judges. They are appointed for a temporary purpose and their objective is to clear the pending cases. Now these ad hoc judges, when they sit as judges, they have same powers as sitting judges of a high court, but for a limited time only. Now what is the legal basis for this ad hoc judges? The legal basis is Article 224A of the Indian Constitution. I hope you have understood about this ad hoc judges, right? So in fact, the ad hoc judges can hear only criminal appeals. And secondly, they must be part of a bench led by a sitting judge. So they cannot sit alone. They must sit in divisional benches where there will be already sitting judge plus a ad hoc judge, right? A sitting judge plus an ad hoc judge. And in fact, they cannot exceed 10% of high court sanctioned strength. So that means 2 to 5 for each high court, the ad hoc judges, and they serve for 2 to 3 years if they are appointed, right? So this is about the ad hoc judges. However, this is very, very important. The Chief Justice of High Court with the previous permission or consent of the President to appoint a retired judge as a high court judge as ad hoc judges. Now what is the good thing about the ad hoc judges is that even though they are retired, we are using their services to hear the cases. And there's a huge vacancy. To overcome the vacancy and also pending cases, to hear the pending cases. So that is the objective with which the ad hoc judges provision has been included in the Constitution. So that's all for today, and thank you so much.